Next up, and we'll start a little bit early, we've got Susan Ebner and Jody Reed, who have spoken in our FAR, DFARS, and FAR supplement webinars over the last couple of years. They've covered various topics, including subcontracting, mentor-protege, joint ventures, and the whole 9 yards. So really happy to have both of these great ladies today to cover legal. So as we mentioned, Jody Reed and Susan Warshaw Ebner. Jody, I'll let you say a couple words here about yourself and firm, and I'll be quiet.
Hi, I work for a very small boutique law firm. It's actually just newly formed. We were smaller before, and we joined with another law firm that was in the same building as us. We basically handle everything in GovCon space, whether it's mergers and acquisitions or my specialties, in addition to just general government contract stuff, is subcontract agreements, prime contract agreements. I do a lot of work with transactional intellectual property kind of documents. I'm also heavily involved with a lot of the cybersecurity stuff that goes on, and that's kind of the 2-minute thing. So I can almost promise that Susan and I will get you back on track time-wise.
Okay, good stuff. Well, thanks so much for joining us today. I'm looking forward to your presentation. And Susan, thanks so much for joining us. The floor is now yours.
Thanks, Jan. I want to thank you for asking me again to participate. It's always a pleasure to work with you and, of course, with Jody, too. I'm a partner at Stinson LLP, where I chair the government contracts and investigations practice. I have more than 40 years of experience advising and representing clients, including lots of small businesses, on all aspects of government contracting, including prime and subcontracting and teaming, other transactions, bid protests, and small business size protests and appeals. I also get involved in the contract administration and compliance issues, audits, investigations, and dispute resolution. If you want to know more about me, as the other speaker from the last session said, check out my LinkedIn profile. I would love to have everybody befriend me. Back to you, Jen.
Great, thanks, Susan. And again, thanks, Jody. We are now into the legal session. This will be the second half of today. And we will go ahead and begin. So I'm going to mute myself, and you guys just let me know when you're ready for your next slide.
Sounds good. So just to start off, the big overview, we've been talking and hearing about a lot of things on the business side. You're hearing about compliance too, and what you need to do to get business, perform it, and keep it. So today we're going to talk very top level, because we don't have a lot of time, on how these business needs get translated into agreements and activities that are lawful, enforceable, and which will help you get paid for what you deliver, and to protect your intellectual property from unauthorized use, release, or even theft. We're going to talk about the subcontract itself, and then helpful hints and pitfalls. And last, we'll talk a little bit more about some useful common best practices. Next slide, please. So the subcontract, if you haven't seen one, a lot of different pieces of a subcontract. You've probably dealt with TV agreements and non-disclosure agreements, or NDAs. The subcontract lays out what it is you're supposed to do. It's much like a prime contract in terms of contract line items, what your data you're supposed to deliver, what your pricing is, your statement of work, those flow down clauses, both the normal FAR ones and then the special ones, representations and certifications, and hopefully points of contacts, and in terms for how you get paid. Next slide. Jody?
Hi. So we're going to talk a little bit now about some helpful hints and some specific FAR clauses that are more important. I'm not going to say all the FAR clauses aren't more important, but of course we can't talk about all of our clauses. So we've kind of picked the ones that from a subcontracting perspective are some of the most critical ones that you need to pay attention to. We're going to go fairly quickly through this initial page, and we're going to probably spend most of our time on the last couple of slides, because that's really where I think you, from a subcontractor's perspective, it's where you get the most attention most of the time. Next slide. So in an ideal world, and way back when, the government came up with the idea of buying stuff as though they were a commercial entity. And for those of us who've been around a long time, in the mid-90s, there was something called FARA and FASA. And those two clauses, those two pieces of legislation, those two acts basically did a good job of turning things more into a commercial contracting. Since then, Congress has ate away at that commercial contracting, but it's still, from a subcontractor perspective, a much easier way to contract. And in fact, your prime contractor is only required to flow down a very, very limited number of clauses if you are providing either a commercial item or a commercial service. I will also point out that there's been a recent FAR change that split those two definitions up, and the definitions are actually in FAR Part 2. And if the one thing that's key is, and they also, in doing that, one of the things that they did, and I think this is really, really useful for people, is if you provide a commercial product, there's always been a concern about how to have a commercial service. And now they're basically saying if it's a service that is similar to or pretty much the same as, or applying to the commercial product, that you would have that same kind of service if you were selling to a true commercial company, then it can also be deemed a commercial product or item. The commercial item provisions and clauses are much, much less, but you still might have unique terms and conditions. And unfortunately, a lot of prime contractors, even though you're selling a commercial product, will try and have all of their terms and conditions that's in their contract flowed to you, and you just simply need to push back. Next slide. In FAR Part 12.5, there's actually a list of clauses that are not applicable to commercial items. And I also want to make clear there's a difference between COTS, which is commercial off the shelf, and just commercial items itself. And finally, there should be a streamlined solicitation and valuation methods. And the big prime contractors, even though this is kind of for the government is direction, for the big prime contractors, they pretty much follow the same rules and regulations as though they were actually a governmental entity. Next slide. And this one comes back to
me. So FAR Part 13, simplified acquisition procedures, as Jody was talking about, there's lots of different kinds of contracts out there. Simplified acquisition ones are more streamlined. They may be more streamlined because they're micro-purchase threshold, or they're below the simplified acquisition threshold, or they're commercial items that meet certain dollar thresholds that are listed here. You're going to be putting in these provisions and thinking, I'm doing a simplified acquisition, I'm a subcontractor, and so it's going to be less clauses and less things to worry about, whether it's a government purchase card or it's going to be a formal contract. Either way, you're going to have flow down clauses that you're going to have to be responsible for. And I think that we'll leave it at that, just so that we can focus on the other things that are coming down the pike that are really key to subcontracting. Next slide, please. FAR Part 16 is another kind of slide. It talks about all the different kinds of contracts that you've got out there. The most important thing is to select the right type of contract. So typically, if your prime contract is going to be a cost reimbursement contract, it may be that they're going to flow down to you a cost reimbursement subcontract. But there could be times when you're delivering a specific widget or series of widgets or a fixed price service where you can get a fixed price contract. So you'll have to be thinking about that when you're entering into your subcontracts. The other thing you want to think about is nowadays we have a lot of things in the supply chain that are creating risk out there. There are contracts like fixed price EPAs, which are price escalation clauses. Those might be in the prime contract. And if they are, you should see if they can get flowed down to you in a subcontract. Additionally, even if they're not in the prime contract, you may want to see if you can get that included in your subcontract. Even though you are a subcontractor, you are supporting the prime contract, and typically your subcontract is going to be a mirror of whatever it is that they do. There are things that you may want to ask for that are above and beyond, or things that perhaps you want to ask for and then get the prime to ask for from the government in order to protect you and make sure that you can perform the way you need to perform. One other thing about this are fixed price contracts. If you're a small business or you're new to the area, you may not have the systems and controls in place to be dealing with cost contracts. Those contracts are very complex. They have more clauses, more requirements for tracking money and making sure that everything is like in its appropriate cataloging column. Fixed price, typically fewer clauses, a little bit more forgiving. So those are things to think about when you're picking contracts. Next slide.
And I'd like to just comment a little bit as you're looking at, she's going to the next slide, is the order in which the risk goes. So firm fixed price, the highest risk is on the contractor, the subcontractor. Lowest risk is obviously on cost. Firm fixed price is least risky for the prime contractor, and cost is most risky for prime contractors. So that drives sometimes what the types of contracts can be as well.
Yeah, I would just add to that recent cases, particularly in the COVID area and with inflation, contractors have been getting stuck with fixed price contracts with no wiggle room to recover for the increased costs. So if you have that kind of situation, that's definitely something you want to get ahead of as soon as possible. You want to try and resolve it, not at a claim stage, but at a contract either negotiation or change stage where you can substantiate the exact reasons why you're being impacted by this. But Jody's right, fixed price is always, it's a less risky proposition because you have a finite amount that you have to do for a finite price. But there are problems these days with COVID and the supply chain that make it a little bit risky from an inflation and other kind of issue that you really want to watch out for.
And
yeah, go ahead.
And DoD has actually gotten a little bit ahead of that in that they have put out a DFAR. I'm not sure, is it FAR or DFAR?
It's an OSD memorandum and
an OSD memorandum. Then okay, but it is Department of the Defense that they're basically telling the different government contracting organizations that if you get a contractor coming back in and asking for more money because of inflation, that in essence, that is a justification to give them more money. But I haven't seen any of it being implemented at this point or any of the contracting officers actually granting that. Have you heard any of those, Susan?
No. Well, I would say this. I did most important cases for the ABA and did a whole thing on all of these COVID cases. And the only ones that gave any relief were where they were actually able to show that there was a change, like one that you would normally see under the changes clause. The DoD provisions that say, you know, if they say it's going to cost more money, consider it. It's an unfunded mandate, meaning they have not allotted money to pay for it. So again, it's really going to be you having to establish why it is you're entitled to it and really turning square corners on the changes clause and what it really is going to take to make that happen. If you find yourself in one of those situations, I think best advice is consult with counsel to see if they can come up with something that's going to help you on that. FAR Part 16, lots of different kinds of contracts. So we have the fixed price and the cost reimbursement. But in addition, we have these things called indefinite delivery, indefinite quantity contracts, sometimes called IDIQs, sometimes basic ordering agreements, BAAs. Those are typically overarching contract vehicles where you've established what it is that's going to be sold and you've established pricing in terms of, it could be hourly rates, it could be prices of materials, whatever. And then they will issue orders, and depending upon how they're issuing the order, they could be asking for fixed price or cost reimbursement kinds of delivery orders or task orders for bidding and getting those contracts. Time and materials are more like cost reimbursement in terms of like you've established what the rate is, and then it's a question of how much time are you going to be spending and what's the cost of your materials. Letter contracts may or may not be definitized. We're seeing a lot of UCAs these days in the very big contracts. Those are undefinitized contract actions. Really would encourage folks that get UCAs or unpriced actions to try and negotiate them as soon as possible. The more you go on in terms of performing contracts, you get to that end, the more they're likely to squeeze you on profit. Say, you've already done it, there is no risk, why should I give you profit? So thinking about that earlier is better. Other kinds of agreements out there, basic ordering agreements and other agreements to agree. There's a variety of different kinds of contracts. The key here is You may think that you're a vendor or supplier, meaning, oh, I'm just sending my commercial items to you. I don't need to worry about these kinds of things. I would warn you that if you're providing supplies, equipment, or services in performance of a government contract, whether you label yourself a vendor or supplier, you are going to have to comply with those flow down clauses that come. So unless you're exempt through some specific commercial item exemption or dollar threshold or something else, you still will have to worry about flow down clauses. Jody, anything to say before we go to the next slide?
Yeah, one other thing is I think this is very important to understand, and it follows up with what you've just said, is your contract with a prime contractor is a state contract. That means it's subject to state law. And there are some states, and there's been some courts over the years that have viewed the entire GovCon thing where we say, oh, but it's self-deleting and stuff like that, where they said, nope, we don't understand what a self-deleting clause is. You allowed it to be in your contract. It is part of your contract. And so that's another thing you really got to watch carefully. And the other thing is that we talked about the fact that time, materials, labor hour, and letter contracts, not so much the last one, but time, material, and labor hour contracts are considered to be cost type contracts. And that has an implication for fee, which basically means your profits you're allowed to do in there is set by the FAR and maximized at 10%. If it's a fixed price contract, your proposal max profit is 15%. If you're selling a commercial item, there is no max profit that is in the FAR. It is whatever the commercial price is that the commercial market is determined is the price, which is another argument, by the way, for going commercial.
And I would say the flip side of if it's in your contract, you have to comply, is if you're a subcontractor and they leave out clauses that at a prime level, they would have to comply with if it's not there under the Christian doctrine, because it's an important public policy. There have been no cases yet that have gone the further of saying, okay, it's not in your subcontract, so even though it's an important public policy, we're going to read it in there. There are no cases that are doing that. So,
well, except for DL Christian originally.
Right. So, DL Christian. Well, you got to have a contract. It typically prime contract. You only get to flow down important public policy. So check and see what's in there. Let's go to the next slide. We're going to try and kind of speed up a little bit, make sure we cover everything. So Jody, back to you.
I think if you take anything else away from this presentation is the government's work with intellectual property is that the organization that creates the intellectual property gets to own the intellectual property. There is no actual obligation on the subcontractor's part to give anything other than a license to the prime to pass it on to the federal government. If you develop stuff, the federal government gets a license. They don't get ownership. There's a couple of exceptions, but we're not going to get into that. But for the most part, contractors keep ownership. Subcontractors keep ownership, or they're supposed to. So when you're looking at, and by the way, I've looked at a bunch of these prime contracts, but one of the things a lot of prime contractors will do is they will put language in there that says, no, they own the intellectual property. And you have to push back. To say, no, I own the intellectual property. You're going to get a license to give it to the government, and the government gets unlimited rights, but there's no obligation on your part to give any more rights to the prime contractors. They don't like it when you push back. We all know that. But the reality is if you're developing stuff and you think, especially if it's something you maybe want to be able to sell to somebody else, you need to have ownership. And that is what is compliant with the law, basically. And the regulations and the Bayh-Dole Act. And if you ever want to read a really cool story, Google the history of the Bayh-Dole Act. And it's a pretty cool history. And I also tell you, the first time I ever heard Bayh-Dole, I never saw it written. I was in a presentation, and I really had a hard time trying to figure out why people were trying to why the government was telling you had to buy Dole bananas. But that was just me.
Well,
Next
I mean,
one.
the other piece about this is asserting your rights. So, I mean, we can't cover all of this in such a short period of time. And maybe Jennifer wants to do something with us where we can lay out a little bit more on how to protect your rights. But if you don't assert it, even if you have bought it, you may lose it. So again,
And it has to be in the contract. Attachment, data assertion.
So anyway, that's another thing to keep thinking of. And sorry, we have to just keep going. But if you have interest in this, just contact us. We can talk to you.
Yes. Next slide.
FAR Part 31. So and a lot of people get scared about numbers and dollars. Top level Part 31 deals with tracking costs that are allowable, allocable, and reasonable. That's the aim of pricing for the government. So you want to make sure you're only going to be charging the government for those costs that are allowable to your contract. And that could be, you know, I'm not going to be charging you for something that I did under a different contract. I can only charge you for the things that are directly under this contract, unless it's in overhead and G&A, right? So you want to make sure you're only charging for those allowable costs. There's a list in Part 31 of the types of costs that are allowable. If you're going and being investigated in a criminal action, that's not going to be considered an allowable cost. On the other hand, if you're involved in a dispute with regard to something relating to the contract, potentially could be an allowable cost. A lot of different rules on this. I don't want to get too deep in the weeds, but Part 31 lays out all the different kinds of costs that are out there that might be allowable. Allocability is the concept of where these costs are going to be allocated among your different contracts. So for example, you may have cost pools out there that you're establishing for your fixed price contracts. And you may have a separate one for your cost reimbursement, or you may have a combined cost pool for both. So depending upon how you allocate it, those costs that go into there, then they get prorated according to the allocability. It's a lot. I'm trying to summarize something, and it's allocable. So if it is allocable to the contract because it applies to it properly and proportionately, that's some of the key stuff. The other piece is you could have allowable expenses. You can have them allocated the right way, but if they're not reasonable costs, then it's not going to meet the last prong of cost principles out there. So reasonableness is one where we're looking at how much you're charging. Jody was talking about commercial item pricing, and you can charge your commercial items. They're not going to look at profit. But reasonableness, if you're selling it to everybody else and then you're trying to charge the government more, like the original list price, instead of what you actually charge them, there might be pushback on reasonableness. There are a lot of other rules on this, but we'll, for the time being, move on. But again, questions, don't hesitate to ask.
And the one key thing about the allowabilities, the reasonableness, way back when, it was presumed in cost type contracts, if you spent the money, it was a reasonable cost. That is no longer true. The government will actually question costs that you have spent that you thought were reasonably to spend.
Exactly true. And they'll do it in an audit that will take time and effort. So
yes,
if you're going to do something, make sure you're documenting everything you do. So it's a lot easier to substantiate what you did.
Next slide.
Jody, you want to go to Part 33? Next slide.
Protests. First of all, you are a subcontractor. You do not have standing to protest. If your prime contractor decides to protest, then you may get a benefit from us. But that's one of the other things you want to look at. I see this all the time in teaming agreements, and we can have a whole nother conversation on teaming agreements. But I see in teaming agreements that once a contract has been awarded, that the teaming agreement expires. Well, if there's a protest, you kind of want to have the teaming agreement still be in existence. So you want to make sure that your teaming agreement language has it continue and all protests are resolved. There's only two places that protests can go. They can either, well, three. Agency protests, which quite honestly, I've not heard anyone say that that's been an awesome way to go. I've seen a couple over the X number of years I've been doing this that had some benefit for an agency protest, but for the most part, it's not very useful. So you're really looking at GAO protests and Court of Federal Claims. And those are the two areas that you can do the protest. And again, you as a subcontractor do not have standing, only your prime does. Likewise, when we start talking about disputes and appeals, the Contract Disputes Act does not apply to subcontractors. No matter how many times I see in subcontract agreements they've included the Contract Disputes Act as a flow down clause, mostly because they were just lazy to not clean up their flow down clauses, it will never ever apply to you. There is a difference between submitting a request for equitable adjustments and the allowability of the costs and submission of a claim. And there's certain requirements that have to go for a claim. And if you ever want to appeal a claim, it has to be a proper claim. It's also going to require that to be a contracting officer's final decision on a claim in order for you to do an appeal. There is something called the Severin Doctrine. And what this does is it allows you to stand in the shoes of your prime or have the prime prosecute and defend on your behalf. Most of the time, those clauses will show up in your subcontract agreements, and they will say also things like, if the contracting officer makes a decision, then that's going to be binding on you. And you just want to be able to have in there the extra language or the extra statement that basically says if the contracting officer makes a decision that affects you, even if the prime contractor doesn't really want to file a claim or request for equitable adjustment, they will agree to allow you to submit that through them to object to the contracting officer's decision, whether it's actually a full-on just within with the contracting officer, or whether it's a full-on appeal to one of the applicable courts. And as far as that goes is concerned, your appeals really are either going to be to one of the two boards of contract appeals or the Court of Federal Claims. There used to be jurisdiction in the other federal courts. That jurisdiction has been removed. Anything, Susan? Otherwise, we can go to the next slide.
Yeah, I guess I would just add in a couple things. One, that, again, you write into your subcontract agreement the terms under which you want to proceed. So sometimes the prime contractor is the one prosecuting the case, but you may have the right, for example, to have your own counsel or to consent to their counsel or to participate. These are things you want to make sure you're addressing how you want to deal with it if there is a dispute. The other thing is sometimes we see subcontract disputes, they don't get to court, they get resolved, or they get handled subject to state law. So the prime contract dispute is going to be at the forms that Jody's talking about, but the subcontract dispute may very well be in a state court. I've certainly appeared at the Fairfax County Courthouse on a subcontract dispute. So it just depends on how you write that. But if you have a dispute with your prime, that will likely go through a state court tribunal, unless there's diversity, which is another complex legal thing that we'll save for another day.
Hey, Susan.
Yeah.
How about if we go down to legal compliance best practices and get those last couple of slides, because we only have 5 more minutes.
Yeah, that's what I was worried about too. I think that's good.
Okay.
So let's move over to slide 19.
Forward.
19?
Yeah,
One
forward
more.
19 is what I'm showing. One more. There we go. Yes.
Okay, here we go. So there's a lot of things that we could cover here. Jody, chime in when you want. Reps and certs, representations and certifications. A prime contractor is required to be registered in the System for Award Management, or SAM. Subs sometimes are required to be registered in SAM. Just remember, if you are not registered in SAM, they are likely to give you that list of representations and certifications for you to certify to, and compliance and ensuring that they are accurate and complete is essential, because you effectively are saying this is the truth. And if there's something that's not accurate, it could expose you to a potential false claim or other kind of problem out there. So if you're asked to sign representations and certifications, you want to make sure they're right. If your situation changes, you want to make sure you're updating it. We've got something in here on size status. If you're a small business and you're getting your subcontract, you are getting your subcontract and representing typically that you are a small business under the NAICS code that was applicable to this contract. If you have a corporate restructuring, you sell, you buy a company, your size status changes, you get a large contract, or you accumulate all these contracts and the revenue size or the number of employees lifts you over the small business size standard for the NAICS code, you may well have a situation where you need to advise on a change in your size status. Although if you have a size status typically as a prime, you get the contract until there is an option. You don't have to be worried about the fact that your status has changed. It's a little bit of a complex situation here, a lot of different rules on this. So size status is something to really watch out for. Jody, do you want to say anything else on size status?
Yeah, so the other thing with size status you have to keep in mind is what's called affiliation. And this is what trips up a lot of companies. They come out and they say, hey, I'm only, I only sell $3 million worth of work. I fit within the size that and this. But they're owned, say, for example, by a equity firm, right? And the equity firm has 4 or 5 other companies. Well, when you look at size status, all those other companies will come into it under an argument of affiliation, and that can trip you over into being a large business as well. And when you trip over to being a large business, there's a bunch of other requirements related to some of your written policies and procedures that you're now going to start having to have. The other big thing that you're going to see these days, and it's huge, it's been huge for some time, but it's gotten a lot of attention anymore, is the next thing we have on here, which is cybersecurity. If you are if you're not in the DoD space, as it stands right now, you only have to comply with the 52204-11 basic safeguarding. And honestly, that is pretty basic. Basically, it's, people coming into your facility have to have a badge. People who are into your computer systems usually have to have dual factor authentication and so forth like that. If you are a DoD contractor, however, your requirements and what you have to be compliant with goes up dramatically. And it's going to even go up more when we start talking about CMMC 2.0, which fortunately enough is probably still not going to get implemented in May, which is what they'd said. They're now looking at possibly the end of the government fiscal year in the September timeframe. But if you're a DoD contractor, you need to be very concerned that your systems are compliant with the cybersecurity requirements that are on the 800-171 and at moving toward a CMMC 2.0.
Okay, Jody, I would just
cut us off.
I think let me just sum up and say there are other issues here we haven't covered today. Not enough time to do it, but domestic preference, infrastructure, any kinds of monies are all going to have domestic preference rules. So really pay attention to what your requirements are and make sure that you're taking steps to protect what you need to protect and that the agreement you have really says what you intended to include.
And one final word from me, read your contract. Seriously, read it before you sign it. And if you don't understand something, contact an attorney.
Great. Thank you so much, ladies. Great to have you both on the program. Susan and Jody, great information. The slides will be sent out in an email. You can also find today's recording on our YouTube channel. That's, if you just go over to jennifershouse.com, top right-hand corner, I believe, has a link to our YouTube channel. If you subscribe to that, it won't cost you anything, and you'll get an alert as soon as this webinar is uploaded.